What I see is that several issues have been raised in this matter, and the court ultimately is to decide whether this CO 272 and 273, whether they're constitutionally valid or invalid. That would be the direction of the court, and that would be the ultimate decision of this court, whether they need to be sustained or quashed. While making the submissions, the councils have made at a different level of abstraction as to what possibly could be the grounds on which these two orders can be quashed. My approach would be to go on more fundamentals, the basics of it. The first premises, which to my mind is extremely important, is the existence of the state of Jammu and Kashmir at one point of time in history and the formation of the Union of India at the same time in history. While as India was being unionized, Jammu and Kashmir state by itself was not a part of India, neither it was a part of British India. Now we have it clear from the various statutes itself, whether it's Government of India Act or whether it's Indian Independence Act, that state of Jammu and Kashmir not being a part of the Union of India at that point of time, nor was a part of British India. It was altogether an independent state. It had its own king, it had its own country, and it had its own laws. The king at that point of time would run the affairs like any other king of any other princely state would do. And the king of the state of Jammu and Kashmir, I will not go back too much in the history, also had certain laws which governed the running of the government, either the state subject definition, which was introduced way back in 1927 and 1932, which applied only to the people who were residing in that state, or from time to time, as has happened in all countries of the world, there have been changes, democratization has taken place, and ultimately the Constitution Act of 1939 was also promulgated by that king. And he created certain institutions in them, supposed to be democratic, but at the same time, he retained all the sovereign powers with him. This was the situation with us. Now, when instrument of accession executed, the circumstance in which it was executed have been already said. They are evident from the letter of 26th October 1947. What is the nature of that instrument of accession has already been read. What was retained and what was transferred or donated to the Union of India. And the subsequent letter of the Governor General dated 27th of November 1947 has also been read, saying that we'll put it to the people of the state whether this instrument of accession is acceptable to them or not. These are facts of history. Having said that, thereafter, after 26th of October 1947 till 26th of January 1950, we have no other document evidencing as to the relationship of the state with the Union, except this instrument of accession. What was sought to be stated by the respondents was that there was this proclamation of 25th of November 1949. The Constitution of India itself was adopted on 26th of November 1949, a day before. That has also been read today morning, and it was read earlier also. It said nothing except that the Constitution of India, as may be applicable to the state, would be acceptable to us. At that point of time, it was the successor of the king who was in chair, holding the position of the Maharaja. So when the Constitution itself was being debated, that's again historical fact. What happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that they need to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today in 2023? What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method? By what procedures? By what process? That's a separate question altogether. The first is, as I would submit for Lordship's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument accession, set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was another factor, that was the matter went to United Nations and resolutions were passed. Those are also parts of your Lordship's Constitutional Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs, accept what I have given to you. This is what I'm conditioned to that. So in instrument accession, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today we call it now constitutional autonomy. Ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like you to say something.
I just wanted to point out, look, we have referred to the history, we have looked at the controversial points.
The premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part, they will be obviously in people of India, there will be people from Punjab, there will be people from Gujarat, there will be people from J&K. Now, the only issue that may not really be, because we have moved with the passage of time, we have to move with the passage of time.
We have moved. That's what I'm saying. I'm coming to that. Yes, I understand.
And now the question today is, really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
It's a question of how the court is viewing the matter. Firstly, we are viewing the matter in a historical perspective, which becomes the foundation of this relationship between union and the state. Well, later on, over these 69 years, have this relationship moved closer? Has this relationship moved forward? And whether there is any possibility in 2019 that we could have done away with the relationship in a sense that Article 370 would go, Constitutional Jammu and Kashmir would go. Have we reached that stage or not?
Mr. Zaffar Shah suggests that if you can formulate your points now that we are in the rejoinder, so that the others also have to look in.
Point number one, Milos.
Yes. My notes of your submissions this morning end with an ocean of autonomy, which I found very interesting a phrase. So I put it into inverted commas.
Milos, my first proposition for the Lord's consideration is this, which I said earlier also, and somehow there were different views on that. That's after the execution instrument of accession. Where did the sovereignty go? That's a very important point we want to make.
Yes.
Where did the sovereignty go?
So how will you formulate it actually?
Yes, that's what's one of the issues involved in this case, because respondents.
So we'll say that the instrument of accession did not result in a loss of sovereignty for whatever reason. Now, what are those reasons? Let's just formulate them.
I'm not going to the reason. I will only cite the judgment of this court.
All right.
That's AIR 1962 Supreme Court 1288.
This is the case dealing with the constitution of the Union Territory Cadre for Honor.
Yeah, there was some grant or something. What's important is that they go into this question when only instrument of accession is executed. That's all. No merger agreement, no supplementary agreement, nothing of that sort. What is its legal status? They categorically rule that the sovereignty will continue to vest in the ruler. This is what is in this judgment. Paragraph 11 of that judgment, well, let's see that. Paragraph 11 of that judgment. I'll have read it, but I don't want to waste time.
Yes, you have read it already.
By my colleagues.
Yes.
There's 11 expressly rules that. So on that basis, I'm saying, because earlier my lord's views were slightly different, in particular Justice Khanna's views were different. So I'm just citing the judgment, a constitutional bench decision, saying that the
You said 135.
paragraph 11,
PDF page 135.
PDF is what?
Which volume?
135.
Volume 6 said.
Volume 6.
Volume 6. Okay, I did volume 11.
Shah, these are just questions and queries. These are just questions and queries. Just like you, this side, other side. These are just questions and queries. That's all.
No, my lord's asking me the question. I was just trying to respond to that. So my first proposition was that Maharaja retained his sovereignty. That's all I'm saying. Now, I also use the word, he retained residual sovereignty, if you lordship may recall.
Yes.
So residual sovereignty remained with him. Then what happened? After it was retained by the Maharaja, later on, at what stage it got transferred over to the people? It did not go into Article 1. It did not go into Article 370. That's what I'm trying to say. It has gone to the people. And it is in exercise of that residual sovereignty that the Constitution of Jammu and Kashmir was made. This is what I'm trying to say. It's incidentally meeting arguments of the respondents also that it was a concession, it was with our permission, so on and so
To
forth.
that extent, you're taking a different projection from others. There's a different argument as what was argued by Mr. Sibal and others.
No, but on the question of sovereignty we are, I don't think there should be much